Welcome to the AIIP Roundtable for Module 3, Voluntary Administration. Again, in this module, I'm joined by Jeanette Muller, a registered liquidator, as is Claire Burney. So today we're going to talk about voluntary administration, a vehicle that's been brought in a little bit later in the insolvency history, however, much used, I would suggest. So just as a general discussion, Claire, what is voluntary administration?
So voluntary administration is a course of action when a director, a secured creditor who has a substantial charge over the business, can appoint a voluntary administrator to take control of the business with a view that the company is either going to, the administration is going to end, enter a deed of company arrangement, or enter into liquidation. Mm-hmm. So it's like a moratorium period of which an administrator takes control of the business to ascertain what assets it has, what liabilities it has, and what options are available to the company.
From media reports, and I have a bad habit of throwing things at TV sometimes, from media reports, the media would seem to think that voluntary administration is liquidation. Would that be a fair comment?
There is a large percentage of voluntary administrations that then do go into liquidation. Mm-hmm. There are some circumstances that arise from that. One of those being that a company who has a winding up application against it cannot enter a creditor's voluntary liquidation. So a voluntary administration is the only option in those types of companies. But at the end of the day, a voluntary administrator should and ought to be appointed in a case where there's a viable option that the company may be able to trade out of it.
Mm-hmm. So with respect to voluntary administrations, it would seem to be an option for directors who are not absolutely sure that their company's in liquidation and are hopeful to be able to trade out of it. But historically, I would suggest that the number of companies that go into voluntary administration, not many come out. Is that a fair comment, do you think, Jeanette, maybe?
Yeah, look, I think that's right. And, there are other reasons as well why one might do a voluntary administration. There might be, this might be a more effective way of compromising debts. So you might do a deed of company arrangement for that reason, and there might be no trading involved. But in respect of successful trade-ons and then coming out the other side in a deed of company arrangement, it's not a lot compared to the number of voluntary administrations that are entered into. It'd be quite a small percent. Don't know the exact figure, but I'd say it'd be less than 10%, put it that way.
Yeah, and that really wasn't the intention of it, though, was it? Well, it was really intended to kind of to some extent mimic the Chapter 11 of the USA and allow people to trade through, and that give them that moratorium from creditors until they get their breath and move on.
Yes, look, I suspect so. I think that was what the intention was. There's various reasons why it hasn't quite reached that. We haven't got that result. It can be quite expensive having a voluntary administrator and their staff in there running your business, just maybe not getting the support of your creditors, not getting the support of your banks, etc., can all add to the ultimate result that whilst one tries to do a voluntary administration, it ends up ultimately in liquidation, as opposed to what the intended outcome of voluntary administration is, which is a deed of company arrangement.
So there is no issue with respect to a voluntary administrator becoming a liquidator if that was the vote of the creditors at their meeting.
In fact, it's automatic unless the creditors decide to put forward a consent from another liquidator.
So you two as registered liquidators, would you say it is more preferable to go via the voluntary administration path before liquidation, or does it depend on the health of the company itself?
I think when you're initially assessing the company, it's important to see what options are available to the company, and sometimes a voluntary administration is a viable option.
It also gives you a bit of breathing space, I suppose, too, doesn't it?
In some respects, yeah.
I mean, if the company if it's going to end up in liquidation ultimately, and everyone knows that, it's a waste of money and time to put the company through a voluntary administration first. There's an extra meeting that's required. Meetings are expensive. It involves writing reports. So, if you don't have to go down the voluntary administration path, or if there's no viable possibility of a proposal for a deed of company arrangement, you shouldn't do it.
Right. So what's the attitude of the larger creditors? I'm thinking tax offices, banks and the like these days to VAs.
Well, we've had one recently where the tax office voted in favour of a deed of company arrangement.
Okay.
So, they'll judge each case on its own merits. It really just depends what the pros and the cons are for each creditor. Am I going to get sued for a preference? Well, then maybe I like getting X cents in the dollars, because you can go backwards if you've received a preference. So some creditors, for different reasons, might be in favour of a deed of company arrangement. It might not just be the cents in the dollar that they expect to receive through the DOCA. It might be, oh, I'm not going to be sued. And for some directors, a DOCA actually enables them to not be sued for insolvent trading as well. So there's very different outcomes with respect to a deed of company arrangement.
All right, so one of the issues we need to talk about, especially for those who want to come into this industry, is the personal liability of insolvency practitioners. In this case, the personal liability of voluntary administrators. So ladies, what issues do you look at when you are basically going to be appointed as a voluntary administrator for a company?
Well, it's true, and it's very important that as an insolvency practitioner, if you're about to take on voluntary administration, that you look at what's the worst case scenario. What am I going to require for trading? Where's my indemnity coming from? And not just necessarily how your fees are going to get paid, but how am I actually going to fund the operations of the business, because you will be personally liable during the whole period leading up to deed of company arrangement or liquidation. Claire, did you have some other comments on that?
And I guess that personal liability is there as a comfort for the creditors, because on the date of the appointment of administrator, it can be creditors that are owed quite a lot of money, and a way for them to continue to support the business is by the voluntary administrator saying, I'm personally liable for this company to be continuing, and any liabilities that are incurred during this period, I'm backing.
Yeah, so it is a decision-making process. Again, you obviously would do your research before putting your hand up to become a voluntary administrator.
Absolutely.
All right, so again, Roundtable for voluntary administration was great, and we'll see you again in modules 4 and 5 when we look at liquidation.